In a landmark judgment, the Supreme Court of India has clarified the distinction between FIR registration and preliminary inquiry under the Criminal Procedure Code and the newly enacted Bharatiya Nagarik Suraksha Sanhita 2023. This ruling has far-reaching implications, especially in cases involving free speech and expression. The case centered around Rajya Sabha MP Imran Pratap Gadi, who was accused of inciting communal disharmony through a poem. An FIR was registered under the Bharatiya Nyaya Sanhita 2023, alleging that his poem promoted enmity and offended religious sentiments. After the Gujarat High Court refused to quash the fire, Pratap Gadi approached the Supreme Court. Under Section 154, subsection 1 of the Code of Criminal Procedure, if a complaint discloses a cognizable offence, an FIR must be registered immediately. No preliminary inquiry is required. Section 173, subsection 1 of BNSS follows the same principle for cognizable offences. However, Section 173, subsection 3 introduces an exception. If the offence carries imprisonment of 3 to 7 years, a preliminary inquiry is allowed before registering an FIR. This requires approval from a superior officer, such as a Deputy Superintendent of Police or above. The Supreme Court stressed that in cases related to speech and expression, a preliminary inquiry should be conducted first. This prevents frivolous FIRs from stifling legitimate free speech under Article 19, subsection 1, Clause A of the Constitution. By quashing the FIR against Imran Pratap Gadi, the Supreme Court has reinforced key procedural safeguards. CrPC mandates immediate FIR registration for cognizable offences. BNSS allows a preliminary inquiry for certain cases, preventing misuse. This ruling upholds free speech while ensuring legal accountability. This historic judgment protects individuals from unwarranted legal actions and strengthens the constitutional right to free expression.